Everybody. It's great to almost see you. Um, my name is Mike Grinthal. I am a lawyer. I work with an organization called TakeRoot Justice, which is a free nonprofit legal services provider. And we work with groups of tenants who are organizing for better living conditions and against gentrification. And we have the privilege of working with Cooper Square, with Jody and Brandon and Jonathan and the great tenant leaders who are organizing with Cooper Square Committee. Cora, do you want to introduce yourself?
Hi, I'm Cora. I'm a lawyer on the housing justice team with TakeRoot Justice. So I work with Mike.
And then Cooper Square folks, do you want to also introduce yourself?
Yeah, sure. Thanks, Mike. I'm Brandon Kilbasa, and I'm the Director of Organizing here at the Cooper Square Committee. I think many of you know us, but for those who aren't familiar with us, we're a tenants' rights and housing tenant organizing organization in the Lower East Side of Manhattan. Been around for over 65 years, helping tenants fight for better housing conditions, stand up against their landlords, fight for systemic change around housing issues. And I've been organizing with Cooper Square for about 15 years. I'm going to pass it over to Jody, who I work with.
Hi, I'm Jody from Cooper Square, and I'll pass it back.
Hi. And I see also Iapa is here. Do you want to introduce yourself, Iapa?
Hey, sorry, my camera's off. Hey, it's Iapa. Good to see everyone. Thanks for coming out today. I'm also a tenant organizer in Cooper Square, where I live in Lower Manhattan, and I'm so happy that we're doing this.
Yeah. For other folks, if you're able to, on the device you're on, put in the chat your name, and if you're comfortable doing it, where you live, and if you're with Cooper Square or another organization, what organization you're with. So tonight's workshop is on the right to protest, and we're going to be going over different laws that impact direct actions that people do, protests, demonstrations, marches, indoors, outdoors, and in different spaces. So to get us started off, Cooper Square is going to lead us through an icebreaker and then talk about what we mean by an action in organizing. Then Cora and I are going to talk about laws that affect actions in public spaces, on private property. We're going to talk about the laws that protect tenants' right to organize, and a little bit about strategic lawsuits against public participation, SLAP. And then we will end with a question and answer. So during this workshop, we're going to be talking a lot about what the law says people can and can't do. That's not the same thing as what people should do or what it's right for people to do or what people have to do. People may choose to break laws for civil disobedience or may just not be able to follow the law as part of surviving. And that's for you to decide as organizers, as tenant leaders. So as we're talking about what the law says you have to do, our goal is just to make sure that everybody knows where those boundaries are so that if people do choose to break the law, they're able to do it intentionally, knowing what the risks are, and people can make their own informed decisions about how to interact with the law.
Great. So we're going to start with just some basic icebreaker kinds of questions to get you thinking about the issue that we're here to think more about tonight in general. So the prompt here is to turn your camera off if you agree with the experience or experience if you agree or have experienced the following situation. But you could easily raise your hand or your Zoom hand or your physical hand or put up an emoji or do something else to indicate that you have had this experience or you agree with the experience. So do whatever you please that way. It's just a fun way to get us thinking about this issue as we head into the actual content of the presentation. So the first slide is, if you have had this experience, you agree, your landlord has told you you're the only one complaining. raise your hand or turn off your camera, do something to indicate. Pretty common one we hear from a lot of people. Looks like a lot of people are indicating that has been said. Thanks. We'll go to the next slide. We've got a couple more of these. Your landlord didn't show up at a repair appointment. So they've set up an appointment to do some repair in your apartment and never showed up. We got a lot of hands for that one. Lots, very common. Great. Next one is, you feel your landlord has intentionally mismanaged your building or has done something to pressure you or your neighbors to move out. Again, lots of hands for that one. Lots of thumbs up and cameras, yeah. Great. Next slide is, you have already successfully protested against your landlord. Got a handful of people on that one, yeah. Monica and others, yeah. Stephanie, yep. Excellent. Glad to hear that. Next slide is, the police or landlord employees have shown up at your housing protest. Who else had that experience? Can be both common and uncommon depending on things. Stephanie has had experience as well. Yeah. Thanks, y'all. And the final slide here is, you aren't really sure what your rights are when it comes to protesting. Kind of the core of what we're here to talk about today. So Monica says, yeah, that's the case, and others as well here. A couple other hands raised. Cheryl, for sure. Great. So those are just some slides to get us thinking kind of about the main content of the presentation tonight. And from here, we're going to go ahead and just jump into some of these slides. The first part that Cooper Square is going to talk through is going to be really quick. And we're going to talk about what an action is. And we're not going to get into the weeds at all. The conversation about what an action is and how to plan an action could be really deep. And could it be, it's really its own training itself. And it sounds like a lot of you all have affiliations with FTC and other organizing efforts, the Sharfman Tenant Coalition. And I think you're talking about that or building those up and doing those already. So we're not going to get into the weeds on what an action is tonight, but we're going to just kind of do a couple slides to talk about it and build the context for the second half of the presentation. So does anybody want to weigh in and share what you think an action is in general when we're talking about organizing, community organizing? What the term refers to? Anybody want to say? It's really, you know, or Cheryl, go ahead, please. Yeah.
Well, from my understanding, what is an action is the building, the tenants of the building that had enough of the landlord and get together to protest the landlord.
That's pretty much it. That's it. It's a general term to talk about that moment where you come together to do something like that. In our circle, an action could be a demonstration, protest, a picket, you know, press conference. All those things kind of refer to the term in general. So, or if you want to jump to the next slide. Yeah, just a couple quick bullet points on this. And again, this is going to be a real, you know, 10,000-foot flyover, some quick stuff just to frame things for tonight. So, yeah, as Cheryl already mentioned, it's a planned event organized with clear goals, something to put the landlord on notice very often when you're talking about tenant organizing. It can be also, you know, your target can be somebody different than the landlord. It could be the city or a lawmaker or some other party you're trying to get the attention of. It's almost always in the setting of some form of escalation. Very often tenants have tried something else. They've written a letter. They've done something else to draw the attention, communicate with the landlord, and that's not working. So you think about what else you could do. So it's, as the second bullet point here says, an attempt to hold a bad actor accountable. A bad actor is somebody you're trying to influence to get what you need, essentially. Public demonstration of unity and power. yeah, your building coming together collectively to say, we're going to go out in the street and show people we're together and we're demanding, our heat and hot water get, returned, that the construction be controlled in our building. And it can take many forms, as I started off saying, an action sometimes is a general term for something like a press conference, a rally, a march, other forms of protest that can happen too. So that's some basic stuff on it. And we have one more slide to cover a couple more things. Cora, if you can jump to the next one. Yeah. So again, it's a very strategic move to do an action. At Cooper Square, when we talk about actions and building up to it, and we teach what we know about this, it's part of the strategy and an escalation strategy. It's never really done frivolously. So you think about, what you want to do here. Do you want to do something like a heavy, big hit, something more targeted? It's something we might call like a light touch, like landlord needs to be woken up, but you don't want to go, you don't want to go too big on the first one because you know that we might need to do something bigger next time. Or your target might be an elected official who you want to show that you can really broker some power and come out in kind of a unified voice, but you don't want to alienate them completely. So it might be, a moment to gauge that. It can be big or small. Sometimes it's just a good handful of tenants can get the attention of, the target, whoever they need. Sometimes you're looking to mobilize a big crowd of people. And it can be done in any number of locations, really. We have them on the steps of City Hall very often for policy issues. Tenants do them in front of their buildings a lot for anti-displacement type issues when tenants are feeling like there's pressure put on them to get out. They'll do something right in front of their building and call up their electeds or call other people from the community to join them. And it's really, ultimately it's designed to achieve different goals. It can be to gather your people together, people that who are united with you, to, get the base together. It can be to, draw some media attention to something that's a common thing that's done in a media event or a press conference. And sometimes it's just a moment to get out there and, strategically speak truth to power. People have been building up around this issue. There's emotion around it, and folks say, we need to get out. I think there's other people like us. Let's get out in the community and talk about this. Let's speak up. And it can work in that kind of emotional way for you yourselves, and also help to cultivate a bigger base and pull people in. So those are some basic things that go into what an action is. It almost always has some tied in unified messaging. There's a plan to it. There's usually a target or somebody that you're trying to, call attention to or put pressure on in some way. So with those couple of slides just to frame things tonight, we're going to go ahead and turn it over to Cora and Mike to talk more about the kind of ins and outs and what you want to, be careful of and kind of know your rights around in different ways when you're doing these kinds of things.
All right, thank you. So we're going to get down into the nitty-gritty now of what are the laws in New York that govern what we're allowed to do and what we're not allowed to do in different spaces. And I want to say again, as I said earlier, there's a difference between what the law says and what's right. And there's a difference between what the law says and what people have to do sometimes. And our goal tonight is to just go over the outlines of what the law says so that if people are faced with decisions of whether to follow the law or not, those can be informed decisions and deliberate decisions. So I'm going to start by talking about the laws that affect actions in public spaces. So sidewalks, streets, parks, plazas, and squares, also handing out written material, and government buildings. The laws are different in New York for each of those. Before we dive into the nuts and bolts of it, next slide, please. The big picture is that the First Amendment to the Constitution says that we have the right to free speech and free assembly. And what that means is that the government can't prohibit political speech or political assembly in public spaces. No matter what laws they pass, they have to allow us to gather and make political speech in public spaces. But the government can regulate what's called the time, place, and manner of how we gather in public. So while they can't outlaw it, they can do things like require permits for use of limited or fragile spaces like parks. They can limit sound volume and the use of sound amplification. They can limit the size of physical displays. They can pass laws to prevent us from impeding traffic or causing damage. And so pretty much all the laws that we're going to be talking about tonight fit within that, within what New York City government does to regulate the time, place, and manner of speech and assembly. So next slide. And one thing to note, no matter what kind of rules the government makes, they have to be what's called content neutral and viewpoint neutral. So they can't distinguish between different kinds of speech. The law can't apply differently based on what you're saying. It has to apply the same no matter what the subject of your action is, and no matter what you're talking about. Next slide. Okay, so let's get down into it. For actions on sidewalks, there is no permit required in New York City to have an action on the sidewalk as long as there's no amplified sound. The police may try to get you to think otherwise, but you don't need a permit and you don't need to inform the police in advance to do an action on a sidewalk with no amplified sound. The one thing you have to watch out for is you have to make sure that the action doesn't block pedestrians from using the sidewalk, which we usually do by keeping moving, like in a picket line. Next slide. And I should say, you know, the other piece of that is that if you do want to use amplified sound, like a microphone or a megaphone, you do actually have to get a permit from the police department. When it comes to the street, a permit is required to have a march of more than 50 people in the street. That's what New York law calls a procession or a parade, and you need a permit for that. And the city can limit those permits if, for example, you want to do a march down Fifth Avenue at rush hour. They can limit permits at times of heavy use of the streets. Right? To have an action in a park or a square or a plaza, you need a permit from the Parks Department if you're going to have more than 20 people. Also, if you're going to set up any kind of visual display that's bigger than 2 feet by 3 feet, or if you're going to use amplified sound. If you look up the rules to apply for a permit in a park, it'll tell you that you need to apply 21 days in advance, but actually, if you're having a political protest, you only have to apply 5 days in advance. And you may even be able to get away with applying fewer than 5 days in advance. The Parks Department is supposed to process those applications if it's feasible, if they can. Next slide. No matter where you are, you can hand out written materials. You have a legal right to hand out written materials in parks, on the street, on sidewalks. The government can't require a permit for that. There is one thing to note. New York City prohibits handing materials to drivers in cars because they're worried that you'll cause an accident. So if you're having an action on the sidewalk and you're handing out materials and the cops are around, I would probably not want to hand materials to drivers in cars, even if they're honking and holding up their fist. Next slide. Posting flyers. This is where people get in trouble a lot when they don't intend to get in trouble. It's illegal to put posters or flyers on any kind of public structure. And that's like telephone poles, fences, walls, mailboxes, unless it's a bulletin board that the city put up that's specifically designated for that use. And this can be especially dangerous because, you know, often our flyers have our names and contact info on them. And I can tell you from direct experience, the Department of Sanitation will actually follow through and figure out who you are. And it's, you know, it's not a crime, but they will fine you. And an interesting thing that I learned the hard way, or at least one of our clients learned the hard way, is the Department of Sanitation actually can subpoena the phone company to find out, to unmask whose phone number it is on the flyer, and then they can fine you for that. Next slide. So not all public spaces are outside. Government buildings are publicly owned, but they're not always open to public use the same way streets, sidewalks, and parks are. So the government gets to make different rules for each building about where you can go in it and what you can do in it. So before doing an action in a government building, you want to look up and check the rules for that specific building, that specific agency. And that may involve contacting DCAS, which is the city agency that manages city-owned buildings, or talk to somebody who's in charge of the security for that building. Next slide. So now I'm going to talk about actions on private property, and I should have said this when we started. We're going to have a Q&A section at the end. So if questions are coming up, remember them and hold on to them, and we will discuss them at the end. So a lot of times we do actions on private property. We go to a landlord's office, we go to somebody's home, we go, well, that's pretty much where we go for private property. And what we often get accused of and what we often have to worry about is whether we're trespassing. So some things to know about trespassing. A lot of private property is what's called presumptively open to the public, meaning you don't have to get permission first before you go there. And that's the kinds of places that are just naturally open to the public, like stores, restaurants, office building lobbies. You know, when you go to CVS, you don't get permission in advance to go into their private property. It's open to people to walk in. The same goes for office building lobbies. And the boundary is usually, you can go in as far as it is obviously open to the public. So for example, if you have to jump a turnstile to get to a certain part of the lobby, then you're probably trespassing. You know, if you have to get past a door that says do not enter, then you're probably trespassing. Likewise, for private homes, the approaches to it are presumably open to the public. So it's okay to walk up somebody's front walk, their driveway, parking lot, up the stoop and knock on the door. Those are all things that we do every day without getting permission first. The thing to know, though, is those areas are presumptively open to the public. That means if nobody says anything, you can assume they're open to the public, but only as long as the owner or somebody in charge doesn't tell you to go away. So once an owner or somebody who has the authority, like an employee, tells you that you're not allowed on the property, then if you stay, that's trespassing, even if it's a place that you can easily walk into, like a store or restaurant. You can enter any part of private property if you have permission from someone who has the right to use that property. So in an apartment building, that could be a tenant or another resident. It could be an employee, or it could be an owner or a superintendent. Next slide. And I'm going to hand it over to Cora to talk about the laws that protect tenants' rights to organize.
So there is a specific New York law designated to tenants' rights to organize. It is, for those who are interested, Real Property Law, or RPL 230, Section 230. But what does it mean that tenants have a right to organize? Under law, tenants can lawfully form tenants associations. Tenants can door knock and leave flyers in their building. We're going to talk about that in a little more depth in a moment. This is just an overview. Tenants can use building space to meet, and landlords can't retaliate against tenants for organizing, for participating in or forming tenants associations. or, doing other things to protect their tenants' rights that are organizing related. So we'll get a little bit more into the details on each of these. RPL 230 says, landlords may not interfere with tenants' rights to form or participate in any group intended to protect the rights of tenants. So to us, we usually call a group like that a tenants association. This means that landlords and landlords' agents or employees, so for instance, the supervisor is probably who you'd be encountering the most often, can't tell tenants not to form tenants associations or otherwise interfere. Landlords and landlords' agents can't withhold or revoke tenant privileges under the lease. So this could be, there's a case in New York City where in retaliation for a tenant organizing, a landlord required that tenant to try to apply for a Section 8 voucher, which is kind of a strange choice, logical jump in my opinion, but the court said that that was not allowed. The terms of the lease can't change, and we're going to talk about this more a little bit with a little bit more depth in a moment too. But landlords and landlords agents can't lessen the terms of the lease, essentially, in order to punish or deter a tenant from participating in a tenants association. Flyering in the building. So it is possible, it is legal, it may even be common for landlords to deny tenants the ability to post, and by post, I mean attach or affix flyers to common areas of the building. I think we see this a lot, that tenants put flyers up and people tear them down, and it's pretty distressing. If you're taping posters up, there's not a clear legal pathway to try to get the landlord to stop you or to stop taking those posters down. However, landlords can't stop you from door knocking in your building, from going around and talking to other tenants in your building, to having conversations, to reaching out in other ways. And they also can't stop you from putting flyers under your neighbor's doors or tucking them into the doorknob. You just can't attach things. One more thing that landlords can say that tenants can't do is hang things on the outside of the building or hang things out of the window. The legal theory behind this is that the outside of the building is the landlord's, it's not yours, you didn't rent it. You see this, people do this all the time anyway, but technically, legally, the landlords can say you can't do that and they can prevent you from doing that. But you can always put a sign in your window. That's in your home. It can be however big you want it to be. It's not attached to the outside of the building. It's all right. The RPL 230 also protects tenants' rights to meet and gather in the building. Landlords can't say, no, you can't meet here, this is my building, to tenants associations. You are allowed to meet in the common areas of your building. So anywhere that you would normally be, the hallway, the lobby, you can meet there. Note that if it is obstructing access to certain areas, to facilities in and out of the building, then the landlord might be able to have a problem with it. But as long as you're leaving room for people to come in and out, you can meet in any common area of the building. Furthermore, the law specifically says that if you live in a building where normally you have to pay a fee for use of a recreation room or a community room, if you're meeting for a tenants association, the landlord has to waive that fee. You do have to make sure that your meeting meets several conditions. It has to be open to all tenants. It can't just be for some tenants, not others. It has to be peaceful, and it needs to be during quote unquote reasonable hours. And those aren't clearly defined in the law, but we can kind of come up with what we think is reasonable. It'd be later on the weekend, it'd be earlier on weekdays. And again, your meeting can't obstruct access to facilities or common areas. These are all conditions that the meeting would have to meet for the landlord to be forced under law to waive the fee. These are not all conditions that apply to you being able to use a common space. The bottom paragraph is just about waiver of fee. Except for the access part. The access part always applies. And what good is a law that says that you can do certain things if you're going to get evicted because of doing those things and you don't have any protection? So real property law also prohibits landlords from retaliating against tenants for participating in tenants associations. This can look like a number of different things, a number of different protections. The one that we tend to immediately think of is my landlord going to evict me for this? Technically speaking, a landlord cannot start an eviction lawsuit against you for retaliatory reasons having to do with your participation in a tenants association. Furthermore, as we were mentioning earlier, the landlord can't alter the terms of your tenancy in retaliation. So this could extend to, if the landlord's like, if you don't live in a rent stabilized apartment and the landlord, your lease is up, the landlord isn't forced by law to renew it, the landlord might say, I don't like you anymore. You were a tenant leader and you caused me a lot of trouble. I'm not going to renew your lease. The law says that that is retaliation and is illegal. Or, a landlord might think that he's being clever and say, well, I'm not going to say that I'm ending your lease, but I'm going to raise it by $260 a month. That's technically also illegal. The reason I'm saying technically is because I tend to err on the side of caution. I don't want to overly inflate the protection of the law. What's written down is different from what happens in practice in the law. And if a landlord can come up with a non-retaliatory reason for taking these actions, for evicting you, for terminating your lease, for raising the rent, for any other thing, then it's going to be really hard to convince a judge that this action is in fact retaliatory. So for instance, if you've fallen behind on rent, a landlord who's mad at you for participating in a tenants association might sue you in a non-pay. And a judge is going to be like, this guy's not evicting you because of your participation in the tenants association. Clearly he's evicting you because you're not paying your rent. And there are ways to get around this. I don't want to discourage people, but I do want to encourage people to just document everything. Obviously, the thing that would be most helpful is literal retaliatory statements that the landlord has made. But short of that, I have a case, for instance, where I'm going to argue that a non-payment case is retaliatory because everybody else in the building is behind on rent. And my client is the only one getting sued. So things like that can be hard to string together in courts that are landlord friendly. But the more you can document, the more you can protect yourself. And finally, pivoting a little bit. So that was a review of the protections of tenant organizing under real property law. I'm going to give you a little bit of information about SLAP. We could do an entire presentation on SLAP, and if people are interested, that's something that we can talk to Cooper Square about. This is just meant to be a jumping off point. It is not comprehensive. I'm sure you'll have a lot of questions coming out of this. It is just to let you know that this exists and to get you thinking about what it might look like. So SLAPs are bad, right? They are, it stands for Strategic Lawsuits Against Public Participation. This is a label that the legislature and advocates have come up with to sort of categorize a certain type of what if it essentially seems like a retaliatory lawsuit or a retaliatory claim that someone like a landlord might bring. So what are some of those types of lawsuits, right? If a landlord wants to silence you or put you down, what might a landlord say? A landlord might say that you're defaming him. I know, unfortunately, Cooper Square has had to deal with this. And defamation is a real thing, right? You can get in trouble for defamation. However, a statement is not defamation if it can be proven true. And it's proven true, not just if it's true, because, right, like you're going to be encountering this issue in a court. So be thinking about proof all the time. It might be true that your landlord is harassing you, but if there's no legal finding of harassment, can you prove that your landlord is harassing you? Maybe not. So be careful about whether or not what you're saying can be proven true, and don't make legal claims if there's not yet a legal finding. And just to be clear, this isn't like you having a conversation with your friend. This is about you making a public statement to a third party, either written or verbal. Another thing that a landlord might do is say that you are tortiously, that means essentially illegally, interfering with a contract. It could be a future contract that the landlord has or a current contract. So a future contract would be a lot of times, like we find it very effective to go to people who might buy the building from the landlord or banks who might want to lend to the landlord, who are not yet doing so. That could be a future contract. If it's a future contract, for what you're doing to be tortious interference, it has to be really pretty like malicious. You have to be doing that thing in bad faith without good reason. So you don't have to be as careful about future contracts, but it's a good thing to keep in mind. If you are if the landlord says that you're interfering with current contracts, sometimes it can be harder to get out of a claim like that. And what we recommend is that you just need to make sure that it's very clear that what you're doing is related to the exercise of your tenants' rights. Because remember, we just talked about tenants' rights and tenant organizing being protected under RPL 230. So anything that falls under the purview or scope of what we just talked about should be protected. But if it starts to fall outside those lines, then there's a chance that the landlord could say you're tortiously interfering with their contract. And finally, Mike talked about trespassing. You can imagine that landlords like to try to bring trespassing suits against tenants to try to silence them. And some pro tips or recommendations to follow up on what Mike was saying is, if you're in a private building, try to make sure that you have an invitation from someone to be there, an explicit invitation. So if you know somebody in the building, keep their contact information, see if you can get them to invite you in. Why are we talking about all of this? Not to scare you, but in fact, to let you know that there is a law that is meant to try to prevent SLAP, discourage SLAP, or at least give tenants a way to fight it. And this law provides tenants with the ability, and not just tenants, but people who are sued in these types of lawsuits, to countersue or counterclaim and say, essentially, this is meant to deter me from exercising my free speech. And in fact, I'm not the one who should be in trouble. You are, and you should pay me damages. So I think you can probably see why this opens up a huge can of worms. We're not going to get into this too much more, but it is good to know about as you're thinking about your right to protest. And that brings us to the end of the presentation.
Yeah. So I just, but right before we start the questions and answers, I just wanted to point out, we touched on two areas here that really are kind of deserving of their own workshops. One was police interactions, or how to deal with the police when they show up. The other is SLAP, as Cora just talked about. So we just want to recognize that both of those are really deep and important subjects, and we only got to touch on. I mean, so we're lawyers, and we just spent a long time talking about what the law says you can and can't do. And sometimes, for shorthand, we say things like, you can do this, you can't do that, you have to do this. But like Jody said, there's a very big difference between what the law says and what's right. And people may break the law out of conscience. People may break the law because they have no choice. People may break the law because that's what they have to do to survive. Um, so when we say you can do this, you can't do that, please hear that as the law says. And so that if you do, choose to break the law, it's an informed and intentional decision, not something, so that if Jumani gets arrested, it's because he planned to get arrested and not because he stepped off the sidewalk without realizing he was crossing a line.